Assalamualaikum warahmatullahi wabarakatuh. So, our group will present about the issue of money laundering. First thing first, what is money laundering? Money laundering is a process of converting cash, fund or property derived from criminal activities such as drug trafficking or terrorist funding to give it legitimate appearance. It is a process to clean dirty money in order to disguise its criminal origin. Money laundering is a serious financial crime that is employed by white-collar and street-level criminals. Criminals use a wide variety of money laundering techniques to make illegally obtained funds. These illegal resources would be tracked down by law authorities and anyone connected would face criminal penalties. Online banking and cryptocurrency have made it easier for criminals to transfer and withdraw money without detection, so that they strive to move the money fast to avoid being tracked by the authorities.
So let's move on to the stage of money laundering. The placement stage is the first step in the money laundering process, and it is essential for criminals to successfully integrate their illegal money into the financial system. By depositing the money into bank accounts or purchasing legal financial instruments, criminals can begin to distance themselves from the source of the money and make it appear as if the money was obtained legally. The second stage of money laundering is called layering, where criminals move their illegal money through a series of complex financial transactions to make it difficult to trace the source of the money. For example, moving money through multiple bank accounts in different countries, or buying and selling assets such as real estate or cars. The last stage in money laundering is integration. The supposedly dirty money is currently assimilated into the economy. When the dirty money has been piled and deposited, the cash will be reintegrated into the legal financial system as legal tender. Integration is done very carefully from reliable sources in order to establish a convincing justification for where the money came from.
We go to impact on money laundering. Money laundering. The process of money laundering is of concealing the origins of illegally obtained funds possessed restricted to national economies and governments worldwide. The infiltration of illicit money into legitimate financial sector and accounts can jeopardize economic and political stability. In this regard, it is crucial to examine the impact of money laundering on different sectors of the economy, specifically the financial sector, external sector, and global sector bear the brunt of these illicit activities. These are three types of factors. The first one is financial sector. In the financial sector, it weakens institutions, increase the risk of fraud, and erodes the customer's trust. This can lead to the emergence of monopolistic practice and hinder the growth and stability of financial institutions. The second sector is external sector. In the external sector, money laundering drains resources from developing economies through illicit capital flight and undermines trust in domestic and foreign financial institutions. It can also distort a country's import and export negatively, impacting economic activity and local enterprises. The last is global sector. On a global scale, money laundering is a problem that criminals exploit, targeting jurisdiction with weak regulation. It can destabilize the global market, shift economic power to rogue agents, and corrupt those operating within it. This threatens the financial system, can expose society to criminal activities like drug trafficking, smuggling, and corruption. Thank you.
I will be presenting the role of auditors to prevent money laundering. First, risk assessment. This is by assessing the likelihood and impact of money laundering risk within an organization to identify vulnerabilities and prioritize efforts to prevent illicit activities. Secondly, compliance verification. It could be done by verifying that the organization has implemented effective anti-money laundering measures, ensuring compliance with laws and regulation, and assessing the adequacy of controls and processes. Thirdly, training and awareness. Educating employees about money laundering risks. teaching them to identify suspicious activities and fostering a culture of compliance and vigilance within the organization. Fourth, transaction analysis. Scrutinizing financial transactions to detect unusual patterns or anomalies that may indicate money laundering, thereby uncovering potential illicit activities hidden within legitimate transactions. Last but not least, reporting. Promptly reporting any evidence or suspicions of money laundering to relevant authorities, assisting in investigations and contributing to the prevention and prosecution of illicit financial activities.
Now let's look at one of the case of money laundering in Malaysia. The case is about JNS Sendirian Berhad. The company is a business that sold fuel-saving product. Bank Negara Malaysia launched an investigation in July 2007 pursuant to Section 35 of Banking and Financial Institutions Act and Section 4 of Anti-Money Laundering and Anti-Terrorism Financing Act 2001. The company was suspected of operating illegally by selling clone version of fuel-saving product. The BNM raided it on July 17, 2007. By June 13, 2014, over 7 years after the incident, it was decided that the company's directors had taken illegal deposit from the public, currently 180 million, without a license. Without the investors knowing, the directors were abusing the Sharia principle to market fake product. Both directors were found guilty under Section 4, Subsection 1 of the Anti-Money Laundering and Anti-Terrorism Financing Act 2001, which carries a maximum fines of 5 million up to 5 years in prison, or both, and Section 35, Subsection 1 of the Banking and Financial Institutions Act 1990, which carries a maximum fine of 10 million or up to 10 years in prison, or both, upon conviction. Fine ranging 21 million to 29 million were imposed on the directors. In addition, the company was penalized up to 3 million ringgit Malaysia. The court concluded that both directors will be sentenced to prison based on counts under BAFIA 1990. The first director raised 6 years in prison for 106 counts, and under AMLATFA 2001, 4 years in prison for the same number of offences. In the meantime, the second director was sentenced 4 years in prison under BAFIA 1990 and 2 years on active 3 counts under AMLATFA 2001.
Next, we go to the key problem. The first one is profit maximization. Profit maximization can be a significant driving force behind money laundering due to the various benefits it's offered to individuals and businesses seeking to legitimize illegally obtained funds. Money laundering enable them to conceal the origin their illicit gains, integrate them into the legal economy, and ultimately increase their profit. The second one is abuse of power. Abuse of power in money laundering involves individual or institution exploiting their authority. Those in positions of power, such as corrupt officials or financial professionals, misuse their authority to enable money laundering activities. They provide access to network, manipulate regulation, or exploit loopholes in the financial system. Abuse of power can also involve concealing or protecting money laundering perpetrators by tampering with records or obstructing investigations. Individuals in influential positions may undermine regulatory frameworks meant to prevent money laundering. Addressing abuse of power requires robust governance, transparency, and accountability mechanisms. Strong regulation and enforcement of anti-money laundering laws are necessary. Individuals in position of power must be held accountable for their action. We go to the third key problem is concealment of illicit origin. Money laundering allows individuals and criminal organizations to disguise the illicit origin of their funds. By integrating illegally obtained money into the legitimate financial system, they create a veneer of legitimacy, making it difficult for authorities to trace their funds back to illegal activities. The last one is asset protection. Criminals use the sophisticated technique of money laundering to protect assets obtained via illegal activity. The goal of this division is to make it more difficult for law enforcement to confiscate or locate the funds thereby protecting criminals' ill-gotten assets from being discovered and seized. Thank you. Next, we go to the next slide.
From the issues stated before, there are some recommendations to prevent the money laundering to happen again. The first one is anti-money laundering regulations. Financial crime is a big problem and business and government need to work together to stop it. And one way to do this is to implement anti-money laundering regulations. These regulations require financial institutions to keep track of their customers' accounts and activities and to report any suspicious activity to the government. This helps the government to identify and prosecute criminals and to prevent financial crime from happening in the first place. The second recommendation is encouraging and protecting whistleblowers. Whistleblowers are people who report illegal or unethical activities. They are often the only ones who can expose corruption and abuse of power. However, whistleblowers can be retailed against, so it is important to protect them. There are few things that can be done to protect whistleblowers. For example, by establish legal protections. Laws should be passed that protect whistleblowers from retaliation. This could include laws that make it illegal to retaliate against whistleblowers or laws to provide financial compensation to whistleblowers who are retailed against. The third recommendation is due diligence. Due diligence is the process of researching and investigating a prospective business partner or client before entering into a contract or financial transaction with them. Banks need to conduct effective due diligence by collect information about customers, review the customer's financial transactions, use technology to help with due diligence, or train employees on due diligence. The last recommendation is transactions monitoring. Transactions monitoring systems are used by financial institutions to identify suspicious activity. This system uses algorithm and pattern recognition techniques to analyze large amount of transactional data. They can identify unusual or potentially illegal trends, such as large cash deposits that are out of proportion to a customer's known income. Transactions monitoring system can also identify transactions that are specifically designed to bypass reporting criteria. For example, if a customer breaks up a large payment into smaller ones to avoid triggering regulatory obligations, the system may flag this as an suspicious activity.
In summary, combating money laundering requires strong measures and international cooperation. Governments, financial institutions, and law enforcement agencies must work together to implement true regulations, strict legislation, and effective tools for detecting and reporting suspicious transactions. Promoting transparency in customer verification and beneficial ownership data is crucial. Improved international information sharing and collaboration among authorities are essential. By enhancing legal frameworks, transparency, and collaboration, we can protect financial systems, prevent criminal funding, and create a safer world. Ongoing vigilance and adaptation to evolving money laundering techniques are the key.